Okay, so without further ado, I will just leave you guys with Dr. Zatil. So Dr. Zatil will be talking about IP, so intellectual property, as I mentioned previously. So we've learned a lot about peptides, we've learned about antibodies, we've learned about RTK, we've learned about vaccines a little bit. So today we will look at on how we translate from research into something that we call as intellectual property. Okay. If you guys have not looked at the lecture notes have already been posted on Spectrum. So you can, while listening to the lecture, you can also go back and see the lecture notes. And of course, if Dr. Zatil finishes early, you can ask her anything related to the topic. Okay. Um, and last one, everything that is covered in today's lecture will also be included as part of your final exam. Okay, so make sure you listen carefully, learn as much as possible, and then make the best out of it. Okay, Dr. Nozatil, please.
Okay, thank you very much, Dr. Hadi. Hi, good afternoon, everyone. Probably I'll start with by sharing my slides. Okay, one moment. Something wrong with my PowerPoint. Let me just okay, well, I'll fix the slides. Let me just introduce myself. Okay, I'm actually Nurzatil from a senior lecturer from Center for Research Biotechnology in Agriculture. So currently my research is mainly on biotechnology for agriculture using RNAi approach, but also looking into the policy perspective of agriculture and food. Well, the topic for today is quite different than the research that I'm doing now, but I actually learned quite a lot about intellectual property back in when I was in Brisbane, where there are a few courses that I took in the university, and as well as I did a 6-month internship at Technology Transfer Office, UniQuest, which is a TTO for the University of Queensland. Also, when I came to UM, I also attached unofficially with UMCIC, which is the University of Malaya Technology Transfer Office. So, okay, so let me just start again sharing my slides. Okay, I hope it works now. Oh, great. Okay, excellent. Okay, so I'll just keep on we'll try to cover as much as possible during this 40 minutes time. Feel free to ask questions at the end of the lecture. Okay, so I just want to start the topic for today with just a bit of introduction why this topic is very important, intellectual property. So just quoting in the words of Mark Getty in an article titled Blood and Oil, published in The Economist back in about 21 years ago. IP is actually the oil of the 21st century. Intellectual property is the oil of the 21st century. Look at the richest men 100 years ago. They all made their money extracting natural resources or moving them around. But all today's research men, they made their money out of intellectual property. So this means that IP is very, very important to make in the current century. So so why we say IP is important? So what are the values of IP? So number one is it gives exclusive property of the owner. Second is it gives proprietary knowledge of a business. And obviously the third point is it generates a competitive advantage, especially in the marketplace. So for those of you who are familiar with the term of startup company, you know, IP is often the only real asset that a startup company owns. And normally this startup company will use the IP as an asset to secure investment from either angels investors or the venture capitalists. And there's a huge industries out there that actually build on this IP. For example, the software industry, because they file copyright for the program codes. And probably the second one, you are more familiar with it, the pharmaceutical industry, where all the patents on the drugs and their users. So they make use of these patents to secure licensing agreements and generate profit. So for today's lecture, what I'll cover is really just give you an overview of the different types of intellectual property rights or protection. But more specifically, we'll be exploring the basics or the essentials of patent. So because patent is actually quite a core IP protection for researchers, especially for chemists or pharmaceutical industry. So the first question that you might want to ask is, what is a patent? So what's the definition of a patent? What is the criteria of a patent, right? And what can and cannot be patented? So there are rules that need to be aware of such criteria of being eligible for a patent. So the next topic will be is how a patent can protect your ideas, and what are the requirements for patent filing in Malaysia. Next, I think I'll take you through briefly of the patent application process. How much does it cost? And of course, a very important thing is the prior art search. What does it mean by prior art? And what are the resources out there that are available for you or other researchers to actually search for patent? So we'll look through some of the lists of the patent databases available out there. Then before I conclude the lecture, we'll take through an example of a patent document. So in this class, I use a United States, the US patent document to look through the important features of a patent. And of course, finally, we'll discuss some of the alternatives to patenting. Say, for example, you are reluctant to file a patent. So what are the alternatives out there for your idea? Okay. So the first topic is the different types of intellectual property protection or intellectual property rights, IPR. So number one is patent. Okay, patent is about giving an exclusive privilege to make or sell an invention for a limited period of time. Number two is trade secret. So what does it mean by trade secret? Trade secret is the means that an IP, intellectual property, or your idea is protected by secrecy or a confidentiality agreement. So it is actually it's not published or it's not promoted as is the patented IP. Usually we assign an agreement, a confidentiality agreement, for example, is the method. Method is usually being protected by trade secrecy. The third one is trademark. So I'm sure some of you might have heard about trademark. So if you've been familiar with the little t and little m, that's actually the sign of trademark. Okay, it's a form of intellectual property protection for a company or a product names on logos that actually distinguishes one product from or a service from another. The fourth one is copyright. Okay, so it is a form of IP protection for something like literary works, arts, music. You know, you listen to the song, they are all copyrighted. Even some of the books out there, they are copyrighted, and also software. Even your thesis is an example of being protected by copyright. Okay. So the fifth one is plant breeders' right or plant variety protection. So this is specifically unique for plant breeders to give them an exclusive right to exploit their respective new plant variety. So for example, if you know some of the research institutes like in Sebar, the place that I'm working now, or even in Mardi, if we are developing a new plant variety, so we can file for a plant breeders' right permit. So the sixth one is the registered design. So the last two was not are not included in your lecture. I just added today. The registered design actually it provides protection of the overall appearance of a product. So that could be in terms of shape, configuration, pattern, or ornamentation. The final one is the circuit layout rights. It essentially provides protection of original layout designs for integrated circuits and computer chips. So so these are basically the seven different types of intellectual property rights, and all of these in Malaysia, all of these are actually governed by our own acts. So any prosecutions, you know, if you you can actually being go to court, being penalized because all these are governed under law and legislations. So I just want to quickly show you an example of how a product can actually have many IP rights. So the first one, if you look at this, this is a bottle of honey. Okay, if you look at the name of the company, it's a Boyne. So I'm not sure whether if I pronounce it correctly. Valley Honey. So and there's a logo D. So this actually protected under trademark. Okay, and if you look at the design of the bottle, so if you look at there's a round button cap, and then you look at the unique shape of the bottle. Okay, so this can be protected under the registered design. Okay, how about the function of the cap? Okay, say the function of the cap is to it can also be protected under patent. Okay, then in terms of the text and graphics on the label, they can be copyrighted. Okay, and more importantly, the methods to the formula to make the honey is a know-how, a secret recipe that is kept in house and it's not published. So it is actually being protected by trade secrecy. Okay. So so that's really just an overview of what are the different types of IPRs, intellectual property rights. I'm sure that you can think of any other examples of that shows that they are being protected by certain types of IPR. So just moving forward from this point onwards, we'll be looking more focusing on a patent. Okay, so what is really a patent? Patent is actually an exclusive right of limited duration granted by a government authority. So in Malaysia, we have a MyIPO. So which really look through all these IPR deals. Yeah. So when I say it's really granted by a government authority, that means a patent is territorial. Okay, means that if you file a patent in Malaysia, the protection is exclusive in Malaysia. So if say, for example, someone, your competitor can, you know, duplicate your technology and they market it in somewhere else, like maybe Indonesia, which you did not file a patent in that country. So you can't, you know, file a lawsuit against your competitor because it's not protected in Indonesia. So when you file this protection, in exchange, you are going to fully disclose the invention. So this is very different to trade secrecy, because trade secrecy, as I said earlier, you actually protect your, usually it's a method, okay, in the form of confidentiality agreement. So you don't disclose it to the public. Whereas for patent, you will disclose it to the public once, you know, after you got your patent being granted. But of course, what are the benefits of getting a patent? It actually prevents or stops others from making, using, or selling what is covered in the patent claims. So I will show you what does it mean by patent claims. Okay. So the third point is a patent will allow you to control the sale of use of the invention. Okay, because you have the power and you own it. Okay, and usually it cover devices, substances, compositions, living organisms. In particular, for example, is the bacterial bacterial that you have engineered, you know, GMO, for example, a GM bacteria, methods or processes. Okay, just an example of why this patent is quite interesting. It's very important actually when you want to make a product down to the market. Because an example here I use is actually a bicycle. Okay, suppose Sylvia invents and patents the wheel. Okay, and no one else can use a wheel without Sylvia's permission. That's obvious because it's already patented. Okay, and then we have another person. We have Marco. He invents the wheel, and that's a patentable idea. So Sylvia herself didn't say anything about the bicycles in her patent. So Marco gets a patent for his bicycle, but unfortunately, Marco can't make any bicycles without Sylvia's permission to use the wheels, because the wheels is protected under this under Sylvia's name. Nor can Sylvia make bicycles without Marco's permission. So what they can do is they can cross licensing. That's one way to do it. So, but I think the key message from this slide is I really want you to get is this is an example of that shows you can have a patented invention, but it's not free to exploit it. And hence, we'll talk a bit more about the ways to exploit different types of patents when you want to pull them together to make a product. Okay. Okay, just moving on what the advantages and disadvantages of getting a patent. Okay, as I said earlier, a patent gives you the right to stop others from copying, manufacturing, selling, or importing without your permission. And it really gives you the competitive advantage for 20 years. So what happened after 20 years? Your patent lapses and it's no longer covered under the patent law. So anyone else out there can actually copy your technology and use it. Okay, without paying you the commission. This is why we see that there's a lot of, you know, when in terms of the pharmaceutical industry, you see that in the beginning of the, when the product is so proprietary, it launched in the market and usually the price will be very expensive because the company, the pharmaceutical company want to recoup the expenses associated with the R&D as well as the patent costs. But then after that 20 years lapse, usually we see the rise of the generic generic drugs, you know, because there are other pharmaceutical companies out there that can produce generic drugs, and that actually kind of like, you know, mimicking the technology that is patented but is no longer valid. Okay, so a patent, why pharmaceutical companies, the big pharmas, they go for patenting? It's really because it's a source of income. You know, at the end of the day, you have to realize that R&D is a very expensive business. Okay, you pump in a lot of money to do your research, but you have to think ahead how you're going to recoup the investment, how you're going to get money from, you know, generate money from the money that you have pumped in, and hence you need to get profit from the licensing and selling, and this is why patent is very important. However, with patent, you know, once you have patent application, means that certain technical information about your invention will be made publicly available. So some of it can be reverse engineered, and people will see your technology. Okay. The process of applying a patent can be very time consuming and lengthy. And of course, again, cost is the most, I guess, one of the biggest prohibiting factor for researchers to file a patent, because you're not just talking about the application cost, the application fees, but you also need to pay fees for doing searches, for the prior art searches, the patent attorney's fees, renewal fees. You know, once you file a fee for application, you still need to renew. You still need to renew your patent up to 20 years. So there are fees associated with it. And of course, if you're venturing into this patent business, you are actually vulnerable to, you know, all those infringement, patent litigation, businesses. All this cost you some money. Okay, I guess, so again, with patent and protecting products and processes, you can actually increase turnover and profits. I think I've mentioned this earlier. Very importantly, actually, you are with patent, you can attract investors. You can license your invention to others, or even you can do cross-licensing. Obviously, when you file a patent, is someone you actually want to be the first in the market, so you are blocking competitors from being the first mover. And lastly, of course, you want to build a reputation in the market that you're targeting. So we're talking about patent is really it's actually a document. Okay, so again, as I said, the patent actually it discloses an invention, and of course, more importantly, it defines the scope of the legal monopoly. So the wording used in a patent document is a combination of technical, scientific, and legal terms. So if you, if I'm not mistaken, you are undergraduate students, right? So if you actually graduated, okay, after you have graduated, and actually, in fact, there are patent companies, sorry, these IP companies out there actually looking for undergraduates or masters or graduates with master's degree with technical scientific background, because when you want to be an IP officer, okay, they actually require some skills, some understanding of the scientific background, and of course, you can along the process when you are in the company, you will learn all these legal terms. So a patent agent or a patent officer, they actually usually comes from the science degree. Okay, the science degree. So so what can and cannot be patented? So if you want to obtain a patent, your product can be a device, substance, composition, living organism, method, and process. More importantly, your product must be novel, inventive, and useful. So this is very, very important. The three important criteria for an idea or an invention to be eligible for a patent. However, what are the non-patentable inventions? Okay, so one is any scientific theories, mathematical methods, any plant animal varieties, because those they are already exist naturally, except the man-made living microorganisms, like I say, like bacterial engineered, for example. The schemes, rules, methods for doing business. Okay. Number 4, the methods for the treatment of human or animal body by surgery or therapy, and diagnostic methods practiced on a human or animal body. This exclusion is not valid in US, but is quite valid in elsewhere. Okay. So let's have a look at what actually usually, you know, some examples of what are being patented in the chemical fields or pharmaceutical fields, if I may say. So number 1 is a compound, okay, which may be defined as a class of compounds or as a specific compound or a group of specific compounds. For example, vancomycin, the antibiotics, you know, vancomycin, carbapenem, so those can be patented, okay. Number 2 is a mixture of two compounds. So for example, you have formulated a polymer mixture containing block copolymers, okay, so that can be patented, okay. Number 3, a composition containing the compound. So for example, you have these compositions containing phenolic compounds, so these also can be patented. Number 4, the articles made from the compound or containing the compound. I put an example, is articles made from a reclaimed polypropylene composition, okay. Number 5, a process for preparing the compound mixture and composition. For example, you invented a process for the production of fertilizers from phosphoric acid, sulfuric acid. So that also can be patented. And lastly is the method of using a compound for a specific purpose. So for example, for curing a polymer system or for treating a medical condition. So these are some of the examples of how these are being actually spelled out in the patent claims and patented. Okay. Okay. For this, I think I just want to quickly mention to you actually why patent actually is important. First off, is of course it protects your idea in the sense that you have that, again, as I say, you have that legal monopoly, and when someone, it could be your collaborator or it could be your competitor, approaches you to actually use your invention, okay, you can actually license the patent to someone else. That actually allows them to exploit it for a set of price or royalty and for the set of time. Okay, so that means that you as a patent owner, okay, you own the patent, but you allow the third party to commercialize it. Okay, so there are different types of licenses. For the first one is an exclusive license, meaning that the ownership is there's only one person acquiring the technology. If you're talking about non-exclusive license, meaning that the license for the patent can be granted to anyone, more than one party, and all of them can maintain control over it and bring it to the market. Because so normally, when you have you file a patent that is foundational, meaning that if I can say, for example, not sure about chemistry, but if I can say from the perspective of biotech, if you file a patent of a new bacterial engineered organism, okay, so or a new plasmid that people are looking, searching, want to use it for many types of applications. This is where you can opt for a non-exclusive license. Okay. The third one is sub-license, where the licensee has the right to issue a license to different organizations for making the product. Okay. The fourth one is cross-license, meaning that there could be an exchange of licenses between two different parties. Okay. Because sometimes if you still remember the example that I used just now about the bicycle and the wheel, because you probably have patented the bicycle, but you did not invented the wheel, but someone else actually invented the wheel, but they also want to use your idea of bicycle, so you can cross license. Okay, this is where cross license exists. The fifth one is the compulsory license. This is quite interesting. Compulsory license means it's quite a little complicated, but it's really it happens when the government allows someone else to practice your patented innovation. Okay, so meaning that actually kind of like forcing the patent owner to give up to a licensing agreement. Okay, if I may quote one example, actually, Malaysia is actually this the first country to grant a compulsory license. It was the case back in 2003 for the HIV and AIDS therapeutic drugs. Okay, so maybe this was actually done following there's a declaration on, I think it's a Doha Declaration on TRIPS agreement. Maybe you can follow up later on after this class finish. What is some other examples of compulsory licensing? Another interesting one is the voluntary licensing, which means that it's really the pharmaceutical companies, they actually voluntarily license out their technology, share for the goodwill of the society. Sometimes they actually don't charge any cost. This is very much relevant, especially during our situation, COVID-19. If you look through, if you can Google about this one, we call as the open COVID pledge. Okay, it was launched in April 2020. It's really a platform that facilitates all the IP holders to voluntarily share their licensed technologies related to COVID-19. So this is an example of a voluntary licensing. Okay, now moving on to the what are the requirements to hold a patent, a valid Malaysian patent. So I think we have mentioned the 3 steps. It has to be novel, new, it has to be inventive, meaning we're talking about novel and new. It does not form part of the state of the art. Okay, so what does it mean by state of the art? It's really meaning that everything is made available to the public by means of a written or oral description. So in other words, it never been disclosed to anyone, to the public. So say if you're looking into from the researcher's perspective, we tend to share our research with, either in lecture, either in discussions with your peers or your friends, or even you present it in a conference or you publish a paper. So once you put that first, once you publish that first or you told someone else first, then whatever that you have told or you shared, it's no longer new or novel if you want to file the patent later. So always the best is to file the patent first, then you share it with others. Okay, so that's novel or new concept. Inventive, meaning that the invention must be it's not obvious. It's inventive, it's inventive. And number 1 is the manner of manufacture, meaning it has to be industrially applicable, meaning that it can be mass produced. Okay. So in Malaysia, patents are governed by the Patents Act 1983 and the Patents Regulation 1986. Okay. So what not to do when you want to consider filing a patent application? So again, you have to always remember that as a researcher, not all research actually worth to be patented. It's always you really have to judge based on your think based on judgment whether your research worth to be patented or not. And this always been think about the cost and benefit analysis of patenting versus publishing. But say you consider to file a patent, then always remember no publication prior to the patent filing, no sale of products incorporating the invention prior to the filing, no lecture or presentation, I mentioned this before, except that you already have some kind of agreement, for example, an NDA in place. And always seek patent professional advice and file before others do. It's very important. So in Malaysia, we have 2 different types of patent. One is a patent, like the one that I've been on mentioning throughout this day. A patent that is protected 20 years from the date of filing. Okay. The other one is a utility innovation. This is quite a unique one. Actually, it's an exclusive right granted for a minor invention, which does not require to satisfy the test of inventiveness as required of a patent. So an innovation is eligible for a utility innovation certificate if it's new and industrially applicable. So it does not have to be inventive. And it's usually protected for 10 plus 5 plus 5 years from the date of filing, meaning once you file a date, you will be granted with a 10 years protection. Then you can seek for another 5 years, for another 5 years protection and another 5 years. So maximum of 20 years of protection. In terms of the timeline, okay, once you start your local filing application, actually then say you decided to go for a PCT filing. PCT means it's a patent cooperation treaty that allows for a unified procedure if you want to file patent applications in overseas. There are actually about 128 states or countries that actually we call it as a contract states to the PCT. Okay, so once you file your application at MIPO, usually we have to go through, if you are in UM, we have to go through UMCIC. Okay, then you can start PCT filing. Okay, then of course, once you start the PCT filing, then there will be a few, some paperwork, some homework needs to be done, and usually it's not done by you. It will be done by the professional patent attorneys to do the international search report, blah, 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 until the 3 months from the filing application where you reach the national phase. What does it mean by national phase? It means that it's a stage where all those search report is completed, meaning that you now to the point where the copies of your application will be shared or will be forwarded to the patent offices of the designated countries. So if you decided to go for PCT and you want to file in just a few countries, so these few countries will receive your patent application. Okay. So how much does it cost? Honestly, I don't have a right figure to tell you that, okay, filing a patent will cost you this much. Because it depends on, first it depends on the jurisdiction that you maintain your protection. So different countries will have different fees. And of course, you have patent attorney costs, and then the cost may escalate. It's just that, for the length of the claims, also have different fees. Okay. But maybe just a brief some idea for you. The basic filing fee for patent registration in Malaysia starts from 1,490. And again, always remember, this is just a basic fee, and you have that cost of the searching for prior art. You have the cost for patent attorney. You have the cost for renewal, patent renewal. So all these actually will incur money. Okay. Right. So I just want to quickly explain to you what does it mean by prior art search. So prior art search is very important for the purpose of patent protection, because it's actually conducted before a patent application is filed. So this is to determine whether the invention is patentable, that is, invention is new or inventive over the existing prior art. Okay. So if there is no prior art related to your invention, then it's worth for you to consider to file your patent. Otherwise, it's not to do it. So there are also other types of searches. For example, the first one is the state-of-the-art search. So it's really just a broad-based search covering all that has been done in the given art. For example, market survey, that could be an example of a state-of-the-art search. Okay. Second one is the FTO, is the freedom to operate or the right to use research. So meaning that it's really if you want to find any potential barrier to commercialization, so you use this freedom to operate. So for example, if you have this invention, right? Say for example, you have a pharmaceutical product. Maybe you have sorry, I think best for me to actually use easier for me to use is actually say for example, vaccine, right? Vaccine, you have this formulation, but you probably need other patent. There are other patents out there that actually kind of like have a method that can help you to mass produce it. So in which in this sense, this freedom to operate analysis will be very useful, because you want to find those who actually can, not just as a barrier, but also you can look for the collaborator or someone that you can negotiate for a licensing agreement for you to be able to commercialize your product to the market. Again, a product is not just just one single thing, because there are many things. Vaccine is a cocktail of chemicals, and it's just a mix of a lot of methods, substances to get one product and out of the market. The third one is infringement searches to decide if an invention infringes an existing patent or claims. The fourth one is the validity searches to verify if whether the granted patent is actually valid or otherwise. Okay, I'm just going to quickly go through what are the patent databases out there. Okay, the first one, we have Darwin Innovation Index, we have eSpaceNet, we have Patent Scope. I think there are some of them are actually publicly available online, like number 2 and number 3. They are free to be accessed. For Darwin, you have to access using library. Okay. USPTO is also publicly available. Google Patents, of course, Google make it open source, so publicly available. And another one is quite interesting is SciFinder, which you can use it to actually get information on patents related to chemistry. Okay. Okay, just I think the last bits of the lecture, just want to go through all the features of a patent document. Okay. So what does a patent look like? Actually, I use this US patent document as an example. So number one is the names and addresses of inventors. Okay. So a patent document will look like this. So you have these names and addresses of inventors, and you need assignees. Okay, who are the assignees? So you know inventors. Inventors are always the researchers. If you do the work, you are the inventors. But who are the assignees? So assignees usually is a company, or if you are in it's the institution, which in this case is okay? They actually own the patent, okay? And that's a priority date. So priority date defines the date of the establishment of the novelty, okay? Usually priority date is the same as filing date, but in some cases it might be not. In this case, if you look at here, the priority date is on the 3rd of November in 2000, but the filing date is actually November 2, 2001. That could be because it was first filed in the country, I guess in this case, perhaps UK, then the filing date at PCT is a little bit later, okay? Because it has to go through the country, the national level first before it can file through PCT, okay? Then, of course, moving on to the next pages, it has a summary of prior art, the review of the field, basically, you know, telling you what's happening in the field, okay? Then, summary of the invention. So it highlights the differences and advantages in comparison to the prior art. And this is a very important part, list of the claims. So anything that you put into the patent claims are actually patent protected and is legal, is protected under legal legislation. So anything that people want to you know, negotiate with you the license, they will always refer to the patent claims, okay? And the last feature is actually the search report. This is basically, if you remember, there's a timeline that I showed you just now. So this is being completed by the patent attorney to actually look through the prior art and produce a search report to ensure that, you know, the patent is really novel, inventive, and new. Okay. So quickly, before I end this slide, what are the alternatives to patenting? Again, we mentioned before that patenting is good, you know, because it gives you money, generate income, because you're going to license it to someone that, you know, wants to use the technology. But let's say you don't want to patent. So what are the other ways for you know, for your research, you know, besides patenting? So of course, the obvious solution, the obvious way, the typical way, in fact, for researchers actually to just publish it. You can just publish it in any journals, you know. It can be cheap if you publish it in journals that does not require you to pay any fees. And of course, when you publish it first, you prevent others from patenting the same inventions because you already created the prior art. However, it does not offer exclusivity. So meaning, again, you will not have that monopoly power. You will not get the advantage, you know, having to get that incomes from licensing agreements. and you will reveal the invention to the competitors. So others may just, build from what you have discovered, what you have searched, and they will work through on that, and they can actually file the patent, okay, based on their outcomes. The second one is secrecy. Of course, it's cheap, but there's a cost to maintain it because you're talking about some kind of NDA agreement in place. It does not reveal invention. However, there's no legal protection against reverse engineering or duplication of invention. It's quite difficult to enforce because it's not by law. It's really based on, it kind of like by law, because you have the legal agreement in place, but it's not as easy to enforce as patents, and secrets can just leak out. It depends who you are signing with. Or you just do nothing. So that could also be the way, but I'm not sure. I don't think researchers will opt for number 3. Okay. So really, patenting is your best option. May not be the best option. You might keep your innovation as a trade secret. But again, you need as I say, you need a confidentiality agreement to protect your trade secrecy. An example is really it's really useful because if you want to retain exclusive use beyond the term of a patent, because patent just offer 20 years of protection, but trade secrecy can last forever. For example, KFC, Coca-Cola, and I put another one is the DNA extraction kit formulation. So all these are protected by trade secrecy. So it's protected forever. Okay. Okay. So I think that's all for today. Thank you very much. Any other questions? Dr. Hadi, I'm not sure how long do I do. How many minutes do we have left?
Can I on the group?
Your voice is breaking, or is it my internet connection is not good? Oh, he just left the meeting. Okay, never mind. Okay, I guess I think I'm not sure. I think this class is just an hour, so maybe I can take a few questions. Because you only have like 10 minutes to 3 o'clock. So unmuted, Dr. Hadi. I cannot hear you.
We actually finished at 2:50. So if
Oh,
there
sorry.
is no question, that's fine. That's okay. If there's no question, thank you, Dr. Zatil, for the.
Okay.
I'm hoping that you guys learned something about patents and all the other IPs, trade secrecies and whatnot. I do hope you also will go back and listen to the lecture again, because for sure I will put in a few questions, especially about key questions from this lecture as part of your final exam. Okay. Anyone wants to ask anything? Okay. If there's none, it's already 2:50. Thank you, everybody, and thank you, Dr. Zatil, for the lecture.
All right. Thank you so much, everyone. Bye.
Bye.
Thank you, Doctor.
Thank you,
Thank
Doctor.
Thank you, Doctor.
Stop recording.
Internet UM.